Today we are going to discuss Austin's theory of sovereignty. John Austin gave a clear explanation of the legal theory of sovereignty in his book Province of Jurisprudence Determined in the year 1832. Austin observed, if a determinate human superior, not in a habit of obedience to a like superior, receives habitual obedience from the bulk of a given society, that determinate superior is sovereign in that society, and the society is political and independent. Analysis of Austin's concept of sovereignty. First point, every state must have a sovereign. It means sovereignty is an essential feature of an independent political society. A state without sovereignty is not a state but a dependency. Second, the sovereign is a determinate person or body of persons. Sovereignty cannot be an indefinite body. Third, the determinate human superior must not obey the orders of anyone. His will must be supreme over all individuals and associations and must not be subject to any control. Fourth, the sovereign must receive habitual obedience from the bulk of a given society and not casual obedience. The sovereign may not be obeyed by all, but this does not harm his sovereignty, because what is necessary is obedience by a large majority of people. Fifth, law is the command of the sovereign. Without him, the state can have no laws. Disobedience to law is followed by punishment. Monistic or legal view of sovereignty. Austin put forward the monistic view of sovereignty, and his theory explains the legal character of sovereignty, which have the following characteristics. First point, absolute. Sovereignty is regarded as absolute because it cannot be limited by any superior power. All persons and associations inside the state are subject to the absolute sovereignty in the internal sphere. The sovereign may of his own will pay due regard to moral principles, customs, traditions, conventions, and public opinion. In case there are restrictions on sovereignty, they are not imposed on it by any individual or group, but by itself, and can be removed whenever the sovereign desires to do so. No state can come in the way of the sovereignty of another state, for sovereignty is absolute in the external sphere also. The sovereign may accept international law voluntarily, not because another state forces it to do so, but to maintain peace in the world. Thus, the state never makes any compromise internally or externally about its sovereignty. Second, permanent. Sovereignty is an attribute of the state. Governments may come and go according to prescribed procedure. The abdication of power by a monarch or the overthrow of a government or the death of a ruler does not lead to the destruction of sovereignty. The government or the ruler exercises sovereign power on behalf of the state. If a state loses its independence and is placed under the suzerainty of another state, its sovereignty is lost. For example, Tibet. Third, universal. Sovereign power is universally applicable over individuals and associations within the jurisdiction of the state. A state grants immunity to UN officials, heads of different states, ambassadors, diplomats and their staff, vehicles and residents for the promotion of friendliness, peace, goodwill and cooperation among states on a reciprocal basis. It's a matter of international courtesy. The immunities can be withdrawn by the state. No international associations and multinational corporation can disobey the orders of the state. For example, in India, Amnesty International. Fourth point, inalienable. Sovereignty is inalienable means that the state cannot part with its sovereignty. When a state cedes a part of the territory along with its population to another state, it sacrifices sovereignty over the specific area only, while its sovereignty on the rest of the territory remains intact. For examples, enclaves given to Bangladesh by India. Thus, sovereignty is the lifeblood of the state and it cannot be alienated without destroying the state itself. As Leiber has put it, sovereignty can no more be alienated than a tree can alienate its right to sprout, or a man can transfer his life and personality without self-destruction. Fifth, indivisible. As sovereignty is absolute and universal, there cannot exist in the state number of authorities, each of which is supreme. A divided sovereignty is a contradiction to the very concept of sovereignty. In a federal system, power and not sovereignty is divided between the federal government and state governments, and therefore sovereignty remains intact. Sixth, exclusive. Sovereignty is located in the state which alone can exercise it. In a state, there can be only one sovereign power whose command should be obeyed by all individuals and associations. These characteristics are peculiar to the legal notion of sovereignty. They are properly represented by an absolute monarch. Criticism of Austin's theory. Austin's theory has been criticized by several writers. First point, sovereignty not determinate or absolute. According to Sir Henry Maine, the determinate human superior as pictured by Austin cannot be discovered. Maine observed that both in Eastern and Western civilizations, a ruler, however despotic, could not disregard religion, customs, and public opinion. For example, Maharaja Ranjit Singh never once in his life issued a command which Austin could call a law. Second, difficulty in locating sovereign. Austen's sovereign cannot be discovered in modern states. For example, in India, is the president, governor, prime minister, chief minister, parliament or state legislature the determinate sovereign? Third, unlimited sovereignty not possible. Sovereignty is never unlimited. It is subject to certain restrictions. For example, in the internal sphere, sovereignty is subject to constitutional law, and in the external sphere, sovereignty is subject to international law. Lasky pointed out that no sovereign has possessed unlimited power. An attempt to exert it has resulted in the establishment of safeguards. Fourth, anti-democratic. According to Austen, people are not determinate and cannot be sovereign. The influence of people exerted through legislature, political parties, media, etc. is overlooked by Austen. Thus, the theory is anti-democratic and out of tune with the time. Fifth, all laws not sovereign's command. Austen defined law as command given by a superior to inferior. This is not true. No sovereign can ignore the existence of customary law. Kinds of sovereignty. Sovereignty is a legal concept, but sovereignty may take different forms under different conditions. First, titular and real sovereignty. The term titular sovereign means a ruler who does not exercise real power. This concept rose with the emergence of democracy. For example, the monarchs of UK and the President of India. They are mere figurehead without being able to issue commands. The term real sovereign means a ruler who exercises real power. For example, the Prime Minister and Council of Ministers of UK and India. Second, legal and political sovereignty. The legal sovereign is the supreme lawmaking authority in legal terms. The legal sovereign is determinate, definite, and visible. The legal sovereignty is vested in one person or in a group of persons. For example, India's parliament. The legal sovereign is elected by political sovereign. The legal sovereign cannot go against the will of the political sovereign. The supreme authority of the legal sovereign is recognized by courts. The political sovereign cannot express the will of the state in legal terms. The political sovereign is not determinate and unorganized. The electorate represents the political sovereign. The political sovereign controls the legal sovereign. The political sovereign is not recognized by the courts. The will of the state is expressed by the political sovereign, and therefore political sovereign cannot be ignored. As put forward by Professor Gilchrist, the political sovereign is the sum total of the influences in the state which lie behind the law. Third, de facto and de jure sovereignty. If the existing regime in a state is overthrown through unconstitutional means, then the usurper becomes the de facto sovereign. The basis of de facto sovereignty is physical or spiritual force or any other factor, but not on the basis of law. The de facto ruler does not have any legal justification to exercise power, but may give his own reasons for overthrowing the legal ruler. The usurper, by continuing in power for a reasonable period, may become a de jure sovereign. The people will gradually forget his act, and through election or ratification, the de facto ruler may convert himself to a de jure sovereign. For example, Oliver Cromwell in Britain, Napoleon Bonaparte in France, Zia-ul-Haq and Pervez Musharraf in Pakistan, the communist government in Soviet Union, Cuba and China. De jure sovereignty is built on law. He is the legal sovereign and has the right to rule and has legitimate claim to obedience. Fourth, popular sovereignty. In the 16th and 17th centuries, the concept of popular sovereignty took shape. Popular sovereignty means that the supreme power is vested in the people. The idea of popular sovereignty was popularized by Marcus Cicero in ancient Rome, who held the view that the ultimate source of political authority is traced to the aggregate people of a state. When Roman Empire became powerful, then the will of the emperor was regarded as the source of validity of law. Later, in medieval Europe, God was regarded as the source of authority. The rulers had to submit themselves to the Pope, who was regarded as a representative of God. An Italian philosopher challenged the absolute authority of Pope because he believed that the authority should be with the people. A German jurist viewed the state as a product of a contract, and hence state must exercise sovereignty to secure welfare of its members. Rousseau's concept of general will gives expression to the idea of popular sovereignty. Today, in democratic states, people delegate functions to the elected representatives. Thus, the rulers are required to function according to the will of the people, which is the basis of modern democratic system.